Hello and welcome to The Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for a decade. We are recording this on Wednesday, June 24th, 2026. In this week's episode, a former NFL scout accused of fatally poisoning his pregnant girlfriend with cocaine. Plus, the potential removal of the death penalty from Tyler Robinson's trial. But first, a Florida man acquitted in a boat crash that killed one of his daughter's friends. Today, we are joined by Vinnie Politan, Emmy Award-winning journalist and Court TV's lead anchor, who you can also find on his very own YouTube channel. Vinnie, hello. How are you doing, my friend?
Great to see you, Josh. We're all back from Vegas. We're all in one piece. Let's go.
I was going to say, have you recovered yet from CrimeCon? That was quite a weekend.
It was. It was just a weekend. I thought it was like 3 weeks, but it was just a weekend. No, it was intense. Great to meet everyone out there and incredible people from the true crime community. So it was a win-win. Although I didn't gamble at all, not $1.
Me neither. I was too exhausted, honestly. Everybody wanted to go out afterwards, and I'm like, you all have fun. I'm going to bed. It was like my saddest kind of Las Vegas experience, but the convention itself was fantastic. And yeah, seeing everybody was really thrilling.
Yeah, absolutely. Absolutely. It's a place where we get together and, you learn more stories. You get to meet some of the people that you talk to, like we talk to each other here, miles and miles apart. And then face to face with the folks who are supporting the true crime community. And everyone is so invested. And I think that's an important part. And that's what makes these stories important.
It's very true. Yeah, we get too used to, I think, kind of sitting in a studio or in a room staring at a camera, and we don't realize the community of people out there. So it's nice to kind of put some faces to names that I've become familiar with. Let's jump in, though, to these cases, because these are some big ones. It was a busy week in true crime. First, out of Miami-Dade County, Florida, the millionaire real estate broker at the center of a fatal boat crash can breathe easy after jurors acquitted the man on all counts. George Pino faced charges of vessel homicide and manslaughter in the death of Lucy Fernandez, who tragically drowned in the accident. Prosecutors claim Pino made, quote, mistake after mistake in piloting his boat that day, driving nearly 50 miles per hour on the wrong side of a channel before striking a channel marker, capsizing the boat. They also argued that alcohol played a role in the crash, though Pino never faced charges related to drinking, and authorities never performed sobriety or blood tests. Pino's defense asserted that the man made a mistake but denied criminal culpability, claiming he never meant to put the passengers in harm's way. The jury ultimately agreed, reaching their not guilty verdict in under 2 hours at the culmination of the 2-week trial. Accepting the verdict, Miami-Dade County DA Catherine Fernandez Rundle maintained the office's belief that Pino acted recklessly, adding, quote, in a case like this, there are no winners or losers. Mr. Pino must live with what he did, while the Fernandez and Puig families will grapple with the consequences of his actions. Go ahead and jump right in, Vinny. 2 hours or under 2 hours for a 2-week-long verdict. That's pretty quick. Were you surprised at all by this verdict?
I thought it was very quick. And one of the reasons I was surprised how quickly it was is that there was no lesser included. George Pino fought against successfully from the judge instructing the jury that they could find him guilty of something less, a misdemeanor. Yeah. And I thought that was very risky on his part, but it paid off for him. So it was all or nothing. He was either guilty of manslaughter and vessel homicide, facing, I guess, 15 years in prison for each count, versus not guilty. And in less than 2 hours, they all agreed. But it was a jury of 6. So you've got to put that into, it's easier for 6 people to agree to something than 12. But the bottom line, it was fast no matter how you look at it.
Yeah. And that's a good point, too. 6 people, probably not going to be as much time for everyone to have their moment to speak as you would with 12 folks. In my view, though, the very clever thing that I thought the defense did in this case is, even though he was never charged with drinking, that was kind of in the undercurrent in all of this, because there were 60-something bottles of alcohol found on that boat. but they didn't have any alcohol tests for him. They didn't have a breathalyzer. They didn't perform any field sobriety tests. They had really no evidence forensically of him drinking. And so the defense kind of made that the question. You know, they can't prove he was drinking, therefore he must not have been reckless. And that seems like an easier question for the defense, given all of the other things that he was doing in operating that boat that may not have been safe. What do you think of that?
Yeah, but from my perspective, I think the jury understands that, like, look, he did not intend to do any of this. His own wife, his own daughter was on that boat, and all the girls that were there were family friends for years. So, like, he knew and cared for everyone that was on that boat. So you couldn't get to the point where, hey, he intended any of this. So how would he not intend to do this? Well, you could intend to drink. And from my perspective, if you're drinking and operating a boat and you are responsible for the safety of all those people, that's where it becomes criminal, just in the minds of the public. Like, we don't like drunk drivers. You're a drunk driver, you kill someone, we know that's a crime. But if you get into a car accident and you haven't been drinking, is it a crime, right? And I think that's the space where we were. So to me, while the defense framed it that way, I think that's the proper framing, even from the prosecution perspective, because we don't want to lock people up for 30 years for an accident where they're being careless and negligent. Like, our system doesn't work that way. Like, it's got to be way beyond that. And it's got to, from my perspective, you have to do something to put yourself in that position. And to me, drinking is the way you would do it. Or if you're texting while driving, you have to me, purposely do something that you know is wrong rather than be negligent, like maybe looking back at the girls instead of looking straight ahead. He claimed, and I don't know if it's true, his story vacillated a little bit, but he claimed that there was a boat that came by and the boat was rocking a little bit and he wanted to make sure the girls were okay in the back of the boat where they were sitting. And then he turned around and it happened. I don't necessarily believe that story, but it was at least one of his stories in all of this. And I feel you need something extra to lock someone up. Civil liability, no brainer. It's his fault. He's responsible. He's in charge of the boat. He's in charge of the safety of everyone on that boat. But to lock him up is the next level. And they didn't have the evidence of the drinking. He may have been drinking, but they didn't have the evidence to prove it and prove it to the level that you need to.
Yeah, and it sounds like the jurors probably went through that exact same thought process that you just explained to us, and he was found civilly liable. I mean, at least he settled. He settled outside of court, or I should say this, to be very specific, his wife settled to the tune of several millions of dollars outside of court. He also had a settlement, but that was undisclosed. So in any case, I agree with you that these are usually handled in the realm of the civil world, and it was, and there was a lot of money paid out. On the criminal side of things, it just sounds like the jurors agreed with you that there just wasn't enough there when you didn't have the drinking, even though there was other indications that he may not have been operating that boat all that safely. They probably just came out with the idea that it was an unfortunate and horrific accident. We're going to have to leave it for now. And that's actually kind of the end of the story because there's no real other lingering lawsuits out there. Let's move now instead to Nashville, Tennessee, where a former scout for the Tennessee Titans is facing a future behind bars after allegedly poisoning his pregnant girlfriend with cocaine. Blaise Taylor is accused of 2 counts of murder in the death of Jade Benning, who is 5 months pregnant with Taylor's child. Taylor called 911 to report that the expectant mother had suffered an allergic reaction and she was rushed to the hospital where her condition became critical. Benning's child died about 2 days after she was admitted to the hospital, with the mother succumbing to her condition about a week later on what would have been her 25th birthday. A toxicology report confirmed that Benning had cocaine in her system when she died, and the medical examiner testified that the mother had drugs in her system far exceeding recreational doses. After Benning's death, Taylor left the state of Tennessee. However, he was eventually arrested in Utah after months of investigation. Prosecutors are seeking a life sentence without the possibility of parole for Taylor, and we will continue to keep you updated on this case. In opening statements, Vinnie, the prosecution played a phone call made by the victim, and she had called a friend before she had become unresponsive, after and rushed to the hospital and eventually dying. And she's heard to say, "What did you put in my drink? I knew my drink tasted funny. You did this because you didn't want the baby." That's probably the most damaging evidence in this case. Walk us through kind of how this is being admitted, though. Is this hearsay? Is this a dying declaration? And do you feel about it the same way I do, that it's fairly strong evidence?
No, it's compelling evidence.
Yeah.
It's the victim's own words, and in the last few moments that she's able to communicate to the world. And to say that, and for her to have the realization and the understanding of what's happened, it to me is devastating to this defendant. And yeah, it's hearsay, but there's an exception. Like, there's some hearsay is permitted. This is a statement, like a dying declaration, an excited utterance. It's something. There's a reason to believe it. It's not like she's taking time to, like, oh, what should I say now to frame this guy and make it, No, I trust these words. Like, this is at the time that it is actually happening. And to me, I don't know how you get around it. If this didn't exist, this would be a much more difficult case for prosecutors. Every case is tough for prosecutors because of the burden of proof. Okay, I'll start there. But with evidence like this, you are at least getting much more of a head start towards fulfilling, meeting that burden of proof. And when the jury hears this, this has the ring of truth to it, right? Something happens to you, you take a sip, and you're like, wait, what are you doing? And she knows the history. In that statement, think about everything that she's saying. She's talking about how and why. Yeah. How and why. Two questions that sometimes are difficult for investigators and prosecutors to prove or try to put together. But she's telling you why he's doing it, and she's telling you how he's doing it. And I don't know how the defense gets around this other than try to absolutely destroy the character of the victim.
Yeah. Yeah, you make an excellent point. It's not just that she's saying, "You put something in my drink. I knew my drink tasted funny," but then she goes far enough to say, "I know you didn't want this child." That is probably the devastating part of the whole thing, is that she then supplies the motive for this whole thing, for jurors to hear from the mouth of the victim themselves, literally crying out from the grave. Pretty powerful stuff. But to your point, otherwise, there's some difficulties in this case. For instance, the medical examiner, though saying that her cause of death was the cocaine, as far as manner of death, having trouble declaring this actually a homicide. We've seen this before. Defense attorneys like to kind of exploit that situation. I think the part of the problem here has to do with the substance itself. We're not talking cyanide, right? If you had rat poison in your system, we could pretty clearly go, this was a homicide. But I think because cocaine is recreationally used, it might give the medical examiner some pause. Do you think there's enough room there for his defense team to sow some reasonable doubt?
Well, that's where it's going to come from. Like, it's the logical argument. Ladies and gentlemen, the medical examiner doesn't even know.
Right.
And they called the medical examiner, and the medical examiner couldn't tell you if this was a homicide or if this was an accident. So, like, how would anyone else know if the one person whose job it is to figure this out couldn't figure this out? So, yeah, that could be a powerful argument. Prosecutors obviously need to be prepared and need to allow the jury to understand that the medical examiner doesn't make the determination of guilty or not guilty. That's your job, ladies and gentlemen. You get to see and hear all of the evidence. And maybe what you have to do with the witness, with the medical examiner, is get into the facts of what did you consider, what did you not consider, right? If you're just doing an autopsy, you're not going to be able to answer this question. But if you consider more of the evidence surrounding it, then maybe you can come to some conclusion. But that's what the jury needs. The jury needs the words of the victim. The jury needs some of the other circumstances surrounding all of this. So I think this is a winnable case for prosecutors, but there is an argument for the defense to make. And this is where lawyers, not the facts, not the evidence, not necessarily the law, but the lawyers themselves can make a difference.
Yeah, you're right. This is one of those rare circumstances. Usually I say lawyers, I don't care how good they are, they can't change the facts. But here there's enough kind of, like I said, wiggle room that maybe a good attorney can get in there.
Let me ask you, which argument would you rather be making in this case?
You're talking about prosecution or defense? I would go for prosecution. Yeah, I'd say for prosecution.
Prosecution, okay.
You know, an interesting thing that we don't know, maybe we do know, but I don't know in the research that I've done, is her lifestyle. Like, that would be interesting to know, right? Was she a recreational drug user before becoming pregnant? I mean, as awful as it sounds, I know that many women listening who have children or are pregnant themselves would say, I would never take anything that would threaten the life of my child. Well, unfortunately, we live in a world where a lot of people do. And a lot of people kind of have their party lifestyle, and they don't want that changing necessarily because they got pregnant. That would be interesting to me. Like, if she had never touched cocaine in her life, and then all of a sudden she's found with a bunch of it in her system while pregnant, pretty clear case to me.
Yes. Now, my understanding is there is some history. I don't know if it's relative to cocaine, but important testimony will be from her OBGYN, who's testifying about there were no red flags. Right. She seemed to be doing everything that she wanted to do. She was very excited about the pregnancy. She was being very careful. And, the jury's going to have evidence like that. So it'll be up to the defense to try to, like I said, they've got to attack her character, and try to make this jury see her in a different light. Don't see her as a young woman pregnant with a child looking forward to becoming a mother. They have to paint a completely different picture.
Yeah. Horrible case, though. Horrific. If true, if he's convicted, talk about a horrific thing.
Yeah, this is Corey Richins and Scott Peterson put together.
Yeah,
that's who this.
Very true. Very good. Very good callbacks there. Yeah. Well, we'll continue to watch it. As I said, the case is ongoing, and we'll keep you all updated. In the meantime, we'll leave it there and move to our final case out of Provo, Utah, where a judge is considering removing the death penalty from Tyler Robinson's upcoming trial after comments made by prosecutors despite a gag order. Robinson, who's accused of assassinating the assassination of right-wing activist Charlie Kirk, had been facing the state's ultimate penalty since his indictment. However, his defense claims that prosecutors spoke about ballistic evidence in clear violation of a pretrial publicity order imposed by the judge. In an unprecedented move, they filed a motion to hold the attorneys in contempt and argued that the removal of the death penalty is the only appropriate remedy. Judge Tony Graff is considering the prospect ahead of Robinson's preliminary hearing, which won't feature testimony from Robinson's roommate and romantic partner, Lance Twiggs. Graff ruled against the defense subpoena requesting Twiggs, deeming the appearance from Robinson's former partner was not necessary at this stage, despite hearsay concerns, which do not apply to preliminary hearings in Utah. Robinson's preliminary hearing is still set to begin on July 6th and is expected to last through the week. Let's get first, Vinny, to this violation of the gag order. So for everybody listening, here's the quickest way to understand what happened. The ATF had a report where they said they could not match the bullet fragment recovered to the rifle, the suspect rifle. But that's all it said. They couldn't make a match. It was unconclusive. The defense wrote a motion where they put that statement into their motion, but they did it in a way that was less than clear, I think is being generous. Media outlets picked that up and ran with it, saying ballistics report exonerates Robinson, kind of almost asserting the idea that he was not guilty because they cannot match the bullet to the rifle, which is not true. So the prosecution said so. They told media outlets, no, this is inconclusive. And most importantly, it doesn't exclude the rifle. Okay, there's the quickest I can do to explain that. But there is a gag order in place. So my first question to you, though, is if you're the judge, do you view that as a violation of the gag order, or do you do that as them simply correcting misinformation that's in the public's sphere?
Well, you have to understand where I come from. I come from a world where I don't believe in gag orders.
There you go. Right.
But is it a violation? I think it's a violation of the spirit of the gag order.
Okay.
I think in a case like this, you probably want to be more careful and maybe make a motion to the judge to see if you can make a statement to clarify the record because of what's being said. What I may have done is maybe in my response to that motion made by the defense, address it in the papers. So they filed something, then we file something, and you kind of speak through your papers. I think it was a risky move. I think it was a little sloppy, especially in light of this case, especially in light of the fact that it's a death penalty case. So I think it's a violation at a minimum of the spirit of it. But to me, the remedy, the remedy is do something to the prosecutors. Don't do something to the system of justice, to the people. Like that to me, that doesn't equate to me, but it could be the remedy. Like we've seen remedies like that before. In Lori Daybell's case, Lori Daybell, cult mom, that was a death penalty case.
Yeah.
Prosecutors messed up. The remedy was no death penalty. And the defense was jumping up and down because ultimately in a death penalty case, that's their first priority and their biggest concern always, especially in a case like this where the evidence of guilt is seemingly overwhelming. We'll see at trial, obviously, but it's seemingly overwhelming. So they're in the game to try to save the life. So if anything happens, their call for a remedy will always be get rid of the death penalty.
Yeah. I agree with you. I think they finally kind of showed their hand here when asking for the death penalty to be removed, because we have seen exhaustive amount of litigation in this case, and we haven't even got to the prelim yet. It's really dragging on. And if you want to know why, well, I think it all comes down to what they revealed in asking for the removal of the death penalty. Is this all comes down to them somehow trying to get that off of the table. And I agree with you too. Well, at least I should say this. The defense agrees with you that it was a violation of the gag order because there's other things they could have done. They could have gone to the judge. They could have, like you said, put it in their own motion. The prosecution kind of said, listen, it's that old idea that a lie has made its way around the world before the truth has a chance to get its boots on, was kind of their thinking, is that we had to address this quickly. We'll see if the judge buys it because he continues to put this on, which kind of brings me to my next question here, is that this case seems to be extraordinary in the amount of time that it's taking in court and the amount of time that it's taking to get to prelim. Do you think this is the judge doing his job, or is this now the defense taking advantage of a judge being probably more generous with his patients than he should be?
Yeah, I think what we're seeing is the defense taking advantage because the clock is on their side. You know, the longer it takes to get to a prelim is the longer it takes to get to a trial. Things can happen. Things can happen. The mood of the public can change. Witnesses can disappear. Evidence can disappear. I mean, it just opens up the possibilities of so many different things happening. I think there's an advantage for a defendant that goes to trial very, very quickly in a very complicated case where prosecutors can't line everything up. But in a case like this, I think what the defense is going to do is there's no harm in delay because they know the level of evidence they have. And, you know, the longer we wait, we've seen it before, you know, things will happen, especially in a high profile case. Especially in a high-profile case because people will talk about it. People will come out of the woodworks. You have a million journalists and independent journalists that are digging up different facts and talking to people, and something may happen. They don't know what it is, but something may happen that may help them. So if I'm the judge, I'm kind of like going to rein everybody in and let's get this done.
Yeah, and I think he needs to do that. And to his credit, he has kept the prelim date on July 6th. They've had plenty of opportunity to ask for it to be continued. He's denied those recent requests. It looks like we are going to be back in court on July 6th to hear this prelim. mercifully. But that is our show for this week. Vinnie, it's always a pleasure to speak with you. You got a lot going on, some new stuff. Fill us all in. Where can people find you?
Sure. So on Court TV's YouTube channel, every night, Monday through Friday, new episode of Vinnie Politan Investigates. The show could also be seen on television at 8 o'clock every night. So two opportunities, whether you're a person who's, online in the true crime community, or if you're at home watching your television, 8 o'clock on TV, and then, a little bit beforehand on YouTube, you can check it out, and it stays there forever. So in case you're away on vacation, you can catch up.
I love it. Love it. Please check it out, everybody. Well worth it. Always so fun, my friend. I am your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, please check out my YouTube channel, Courtroom Confidential. And you can, of course, find all of your Sidebar episodes wherever you get your podcasts. And we would love to hear from you. If you've got questions or comments you'd like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.